Okay, so right now the insurance company is responsible for his compensation payments and his medical issues, and they're continuing to pay. They have no issues, problems with that. What they do is if we settle this case for a lump sum and move forward with this for a large lump sum, if we decide to do that, what he's going to do is he's going to submit this testimony that he's getting through this deposition to the federal government under a different law. We're under the Defense-Based Act, which is a federal law that says that, you know, if he's injured, the insurance company has to pay. The insurance company then, once they make payments to you and they settle your case outright, they can submit the claim to the War Hazards Act, which is a separate federal law, which covers anyone, including employees. You could be a TV reporter that gets involved in a bombing and any type of a terroristic attack on an American person. The War Hazards Act pays for them. So whatever the insurance pays out to us, they can get reimbursed from the War Hazards Act, which comes directly from the coffers of the federal government, the federal treasury. So with that in mind, what he's going to want to know, he just wants particulars as to exactly where this thing occurred, that it was documented by the government, that it was a terrorist attack by insurgents, and that was part of it, and he was there at the time, and he was part of being attacked. And if that's the case, then they can get money reimbursed. Things are progressing. I've been getting a lot of records in, medical records in. I appreciate all that. We got records in. We got a disc in, I think, 2 days ago or so. I haven't looked at it yet. Doreen goes through and she sorts through and does all the medical summaries for us. So what he's going to do is he's going to have a simple questionnaire type thing in front of him. He's going to go through pretty much work history at the beginning, his work history from, say, high school forward. And the jobs that he had in the past. He's going to go through his family life and kind of the background of you know, his life through the family. He's going to then go through the job that he had, the immediate job that he had before the incident occurred. Then he's going to go through the incident, exactly where it was, what he saw, what happened, where the grenade went off, where, you know, basically put him in the situation that was in, and he can describe it in as much detail as he can. That's the biggest part. Other than describing the incident itself, which might be difficult for him to get through, and it's very simple. At the end of the day, all this transcript is simply a Q and A, Q and A. It doesn't say that he had to take a break. It doesn't say that he cried or yelled or screamed or had to leave the room. He can take a break anytime he wants. You can help him through it. You can take a break every 5 minutes if needed. Okay, so but we have to be detailed on that part, on the actual incident itself. They do have the right to ask him background information about, you know, has he ever been convicted of a felony, got that kind of stuff, bankruptcies, divorces. That they're allowed to ask that stuff, but the judge would probably not really. He would probably stricken that part from the record. But in order for them to get an appropriate background, because we are alleging emotional injuries. Along with physical injuries, they're pretty much allowed to ask those types of questions, even if some of them seem to be kind of sensitive. The reason why they're allowed to ask those is because we put his psychological issues into the case, meaning that he's allowed to ask about his well-being, whether he had trouble with his family life, that kind of stuff. And so you just want to answer that. He's allowed to answer that he prepared for this deposition with his attorney on Friday for about an hour. And that's always he doesn't have to answer anything other than that. Everything else is attorney-client privilege between us and what we're talking about. Okay, so he's allowed to say, yes, I prepared for this with my attorney. If he asks anything about what did the attorney say to you, did he tell you how to answer the questions, and you say that's attorney-client privileged, and I would obviously be objecting. But anything that we say is confidential.